Waterman is our presenter. There we go. Okay, I just wanted everybody to know that we are recording. Rachel Waterman is with the Legal Services of Eastern Missouri, and she has graciously volunteered to do a presentation on simple things we can do in the line of estate planning to make sure that we can at least secure our home for the people we want to receive it. There is a simple item that she can speak a lot about, and then maybe if you have other questions that are a little more detailed, she can probably give you some advice as to who to contact or what type of an attorney to contact if you need additional help for something more complicated, shall we say. Okay, this is a different one for Shed because we've normally been just some programs where our webinars have been aimed at the younger folks who are trying to get into home ownership. This time we decided that we're going to focus on a lot of us who are familiar with Shed, who are current homeowners, and a lot of us, myself, retired, homes are paid for, and now really need to think about who gets our home when we die. This is a major asset. It's the largest asset most of us own, and it is a major asset that can be passed on to other generations that allow them to stay out of poverty by obtaining a piece of an asset that gets them set on the right road. So with that, I'll introduce Rachel. Cindy Theory is also on the call with us. She is a realtor here in University City in particular. So she'll talk a little bit about general real estate ideas once we get started. But Rachel, I'll go ahead and turn it over to you.
Yeah, I'm happy to be here. And I am excited to talk to people about estate planning. All right, there's my slides.
There we go. Okay, thank you.
Yeah, I'll try and be just touch on the high points since I know that people have been waiting for a minute. So we can skip this slide and move to the next one.
I'm trying. I don't know why it just, there it goes. Okay.
Okay, there's a quick overview. We're going to talk about estate planning and heirs property in the next slide.
It seems to have a very delayed.
It's delayed reaction. Okay. We can do away with the slideshow if you want, if it's not working.
We're just having all kinds of tech issues, aren't we?
Mm.
I do know it pretty well. I'm happy to talk through it, but
yeah.
If you want,
keep going, and
yeah, by all means, Rachel, go ahead.
Sure. Okay. So what we do in our office, we're a Department of Legal Services of Eastern Missouri. Our team is called the Neighborhood Advocacy Team, and we're focused on vacant and abandoned property. So keeping property from becoming vacant and abandoned. And that's the estate planning and heirs property work. And then we also do the other half of our practice has to do with problem properties that are already vacant, and we do litigation on that. And if you're interested in that, I'm happy to talk about it, but I won't do it tonight. So what is estate planning and why does it matter? Estate planning is just a general lawyer term that's used for any number of types of documents that spell out, here you go, spell out who will take ownership of your property after you pass away. Most people are most familiar with wills, which are also called last will and testament. There's also trusts. And in our case, there are deeds that could be used for your house to transfer on death. All of these documents have special rules, and you should really work with an attorney if you plan to do any of them. Why is it important? If you don't have estate planning and you do have a house, the title to your house can fracture between a lot of different family members, the people who survive you. And often that's not the people who you might have chosen to inherit your house. Your house can also end up stuck in probate court if you don't do any type of estate planning. And if you use a will, you will be in probate court no matter what. And families can end up walking away from property if it becomes vacant, or they live in the property that's still titled in the deceased owner's name, and they won't have access to all the services that they might want as a homeowner. So it's really important to plan ahead and make sure you know where your asset is going when you're gone, even if it's not fun to think about. Okay, estate planning tools. The tool that we use most often in our office, it's really simple and easy, is a beneficiary deed. And that transfers your home after you pass away, and it avoids probate court. So it's a simple document. You do it while you're alive, and then upon your death, it automatically transfers your house to the person you choose. Wills can be used for more types of assets. So a beneficiary deed is for a house only. A will can include your personal property and other assets, but it does require probate court. And it requires an attorney. And a lot of people don't know that the will has to go into probate court within 1 year of the person passing away. And if you miss that deadline, it's invalid. A
Oh,
lot of people also ask us about durable powers of attorney and healthcare directives. So those are actually like end of life documents. So they don't pass anything after you're gone, but they give someone the power to make decisions for you while you're still alive, and possibly incapacitated. So if you appoint a child or a loved one as your power of attorney, as your agent, they can sign on your behalf. They can tell doctors what to do on your behalf. That's all while you're still alive, and it won't apply at all after you're gone. So you need a combination of both. All right, next. If it will go to the next.
I ask. For the beneficiary deed, are we talking about the same thing as a transfer on death?
Yeah, so a beneficiary deed transfer on death, and beneficiary is a general term because you can use beneficiaries and transfer on death on lots of different things. Beneficiary deeds are just for houses, and they're transfer on death deeds for your house. You can call them either one, but the term is used generally. So wills and trusts, requirements for a will: it has to be in writing, it has to be witnessed by 2 other people, meaning they sign it as a witness plus notarized, so both. And then here's what I mentioned before: to be effective, it must be filed with the probate court within 1 year of death. And that's a really, really strict deadline. Courts do not make exceptions. Probate court requires an attorney, so you usually can't do probate court yourself. You can't represent yourself. You need an attorney. Trusts, that's a huge range of documents. Trusts take many, many forms and are usually used by people with larger estates, so more assets, maybe multiple houses, or different types of accounts or substantial investments. And some people use these if they have special requirements for their assets after death. Maybe they have a special needs child, or they have a ton of money and they want it to be distributed to their heirs over a number of years instead of all at once. Trusts can do a lot of different things. We don't do them in our office, but they are an option. Next, if possible. So advantages of a beneficiary deed: transfer on death deed. It allows the owner of the property to name people or organizations to receive the property when they die. It can be one person, it can be multiple people, it can be a combination. There's no court process at all. So you don't need an attorney after the owner is gone. You do need an attorney at this point to draft the document for you, but it's pretty quick. It's a quick document, saves time and money, quick and easy. Debtor advantages: that means that whoever you choose, they don't have any present access to the property. So some people say they want to add their grandchild or whoever to the house now. If you do that grandchild or whoever you add to the title now, their creditors, anything that happens to them and their money is now happening to the house. So once someone's name is on the house, their creditors can reach the house, and lots of things that people don't anticipate. So that's why we usually recommend a transfer on death, unless there's a really, really good reason to add someone to the house while you're still alive. No present interest: grantor remains the owner. Beneficiaries' creditors cannot reach the property. So that's what I just said. And then it's easy to change or revoke before death. So you can always do a new beneficiary deed if you change your mind about who you want to leave the house to. Next one. That's the document. So this is what we do for our clients. 1 page. Sometimes, well, actually, it often ends up being 2 pages because the recorder of deeds will put a cover page on it once they record it. But the document that you actually walk away from our office with is 1 page, quick and easy, avoids probate. This is a city one, so you'll see the city's recorder stamp there in the top right corner, but the county does a cover page. That's why you end up with 2 pages. So yeah, that's it. The owner's name is on there. The beneficiaries' names are on there. That property description, which is super important, you get that from past deeds, is on there. And then it's signed by the owner and then it's notarized. It doesn't have to be signed by the beneficiaries at all. So it's just the owner can do this document. They don't even have to consult with their beneficiaries, though of course we recommend that you tell your beneficiaries that you're giving them the house so that they're prepared. And you can do this if you have a mortgage on your house too. It doesn't, when you're gone, your heirs become responsible for your mortgage, but there's no rule against doing this while you still have a mortgage. Next. So here's the steps for doing a beneficiary deed with our office. You call or email our intake hotline, and that information will be at the end. You'll speak with a paralegal. If they don't pick up the phone or reply right away, we have Thursday meetings where we review all of our calls. So usually you get a call back within a week. If eligible, the paralegal will complete the intake process with you as a client. Your case will be assigned to an attorney. The attorney will briefly review your title records just to make sure you do in fact own the house. If there's any really noticeable problems with your title records, they'll let you know. And then the attorney will contact you to discuss your case, meaning mostly who are your chosen beneficiaries. We'll draft the document and set up an in-person appointment. We can do home visits. We prefer to meet with clients at our office so that we can change the document and go as we go over it with you if we need to, but if you require a home visit, we can do that. And the beneficiary deed will be signed at that appointment with a notary from our office, and we will record it with the recorder of deeds, close your case, and mail you everything. All right. This is examples of other things where you can name a beneficiary or do a transfer on death. So your car, if you go to the DMV, you can appoint a transfer on death beneficiary. And you can also do this for your bank accounts, life insurance, retirement accounts. You just would speak with a specific institution. So if you have a US bank account, you call US Bank and say, I want to name a beneficiary on my bank account, and they can do that for you. Same with your retirement, any other account that a financial institution manages, they'll allow you to name a transfer on death beneficiary or multiple. Why transfer on death? I sort of mentioned this, but adding friends or family to your accounts or your property while you're still living is risky. And that does include bank accounts too. So if you click to, there should be some text that shows up. Okay. So one example is a grandma who adds her granddaughter to her bank account to help her manage her bills while she's sick. Granddaughter is sued for past due credit card, and the creditor garnishes money from grandma's account, because as far as the credit card company is concerned, they don't know that it's grandma's account and granddaughter is just on there to help. To them, it looks like it's a joint account, and that's granddaughter's money, so they can capture that money. Granddaughter can make withdrawals from the account without grandma knowing anything about it. Another example, Donna is retired, lives on a fixed income, worked for 30 years to pay off her home. It's her most important possession. She wants it to stay in her family when she passes away. So she signs a quitclaim deed, adding her son and daughter to the title. Then Donna decides to get a loan to improve the property. Her loan is denied. That's because her son was sued for past due child support, and a court judgment was entered against him. Now there's a child support lien on the title to the property automatically because his name is on the property too. That means that a bank is probably not going to lend to her because there's already a lien on the house. Choosing a beneficiary. How do you decide who do you leave your house to? We always say less is more. A lot of people want to leave their house to everybody, but the fewer the better, just because it's easier to manage property among 1 to 2 people than 5 to 7 people, because whatever happens to the house in the future, every single person on there is going to have to agree to that. So they're all going to have to sign all of the paperwork, and they're all going to have to agree to buy, to borrow, whatever. So we encourage less. We encourage you to think about who actually needs or wants the house. You know, do your other kids or family members already have houses that they live in and are happy with? Is there a family member who has shown a special interest in the house, or, you know, has lived there at a point in time in their life, who knows how things works? Who all gets along? So that's number one. If you're putting multiple people on there, do you trust them to get along and make decisions together? Because if they can't, they'll be at a stalemate. Who's financially responsible? So again, you know, who do you feel like is safe from creditors, and who can manage a large asset like that, especially if you still have a mortgage on the property? Who's going to take over that mortgage? Who has debt? Same question. If you leave the house to one child, can you leave other assets to other children? So that's always an option. If you have one kid who wants a house and you have money in a bank account, you can leave the house to that child and the bank accounts to another child. So There's ways to be fair without splitting the house in half. Next. Heirs property is what happens when an homeowner passes away without any kind of estate plan at all. The law is going to automatically divide their property between all of their living descendants and their spouse. You go on. That can be a big group of people, especially if the homeowner dies and then some of their descendants also die. So you can end up with children, grandchildren, you can end up with spouses, and then you can end up with stepchildren. If there's no spouse or children, you end up with siblings, nieces, nephews. It gets really complicated really quickly. That's why it's best to plan ahead. But there are some things you can do if you're already in this situation where the homeowner is already gone. You go ahead, we can talk about. So you want to clear up the title as soon as possible because that's going to give you access to bank loans, home repair programs, the ability to sell, the ability to get mortgage assistance. As long as the home is in the dead homeowner's name, we say you don't have clear title and you're not going to be able to access any of these normal things that a homeowner should be able to access. So the sooner you get it cleared up, the better. You can go on.
Rachel, what does that mean, clear up the title?
Update it, so get it out of the dead homeowner's name and into their heir's name.
Okay.
There's a lot, it's called heirs property, it's called tangled title, it can be called clouded title.
Okay.
So someone studied this in Philadelphia and found that there was more than $1.1 billion in homeowners' wealth that was tied up in this heirs property problem, meaning that those homeowners were gone and no one had updated the title. That's probably common in St. Louis too. We see it constantly in our office, and we know that we're only seeing a small portion of the problem. Go ahead. So there's lots of myths that people think, you know, I lived in the house with my mom and my mom's passed away, and so now it's my house. It's not the case. If there was not an estate plan, if there was nothing documented, then it doesn't just pass automatically to anyone. If you pay the taxes and the bills, that does not mean you own it. Unless you've done that exclusively for 10 years and no one else has objected to your ownership of the house, then you can make a legal claim to adverse possession, which is kind of a legal term for squatters' rights, but that's a long time to wait. So paying the taxes and the bills is not a route to ownership in any sort of quick way. People will say, I never signed anything, so I don't have an interest. That's also not the case. The transfer of the interest is automatic upon the death of the owner. So if you are a legal heir of the owner as a child or grandchild, you automatically inherit that piece of the house. You would have to sign something in order to take your name off of the house, but it comes to you automatically. Legal separation and marital interests. This is something that comes up a lot. In Missouri, you need to be legally divorced in order for your spouse to not have an interest in your property. Just because you are separated or you haven't talked to them in a long time, they will still inherit half of your property when you die unless you get legally divorced from them. So that will be an unfortunate thing if someone comes in, they say, oh yeah, my mom remarried right before she died, but we don't talk to stepdad. Well, because they got legally married, stepdad inherited half of mom's house, whether you talk to him or not. So just thinking ahead about marriage decisions, and if you do have a spouse, knowing that they have a right to your property unless you make an estate plan to the contrary. Predeceased siblings, we also see this a lot. So if so a house is in mom's name and mom had 5 kids, but 3 of them have already passed away. Those 3 who've passed away don't not count. Now their kids stand in their shoes. So that's how you end up with grandkids having an interest. So you'll have the 2 living siblings plus all of the children of the 3 deceased siblings. They'll all have an interest in the house. Next. So that's where you can contact us for legal help. We can help with the heirs property problem. It's a more complicated set of documents. And we can't always help with it. So that's why I bring it up second, because those get complicated. We need to know a lot about the family tree, and then we need to know if the family's in agreement about what happens to the property. But it's definitely worth calling our office so that we can look at it for you and ask you the right questions. And this is where you would do that. So you can email us or you can call us at that phone number. Okay, that was my quick version of the presentation. I would love to hear questions and see what
Okay,
you want.
everybody, please, I was gonna say, everybody, please write down that information, that email or that phone number if you do have questions, because as you heard from the different scenarios, there can be some complications. Sometimes it's very cut and dry, and sometimes there's a lot of stuff going on among family members, and it may be a special something. Okay, she put it down there again. Just make sure you record all that. Okay, can anybody use your services, Rachel, or are there any stipulations or requirements or minimums or money
Yeah,
or age or anything like that we have to meet?
we have age and income restrictions, and they're very complicated, but in general, I can say if you're over 65 or if you're below 300% of the poverty level, give us a call and we'll do our best to make it work. Even if you think you're like near that, you can give us a call. But our work is all completely free if you work with us. So we're grant funded and all of the grants have different requirements about who we can serve, which is why it's hard to say for sure, because those grants are different by region and different by grant. So give us a call and we'll figure out if you're eligible for our services. If you're not eligible for our services, there's no like sliding scale where you pay something. Either you're eligible and it's free, or you're not eligible and we have to refer you to a private attorney. Or sometimes we have another partner who we think might be able to do the work at a lower cost, but that'll be dependent. And right now, currently, so we have 3 attorneys who do this work, and it will depend on our capacity. We're currently close to capacity, so if you call us, it might mean you're on a wait list for a month or 2. But we'll still take the call and let you know.
And how long does the process normally take?
It depends how complicated your case is. If it's a straightforward beneficiary deed, you can be intaken and done within 2 weeks.
Oh,
Yeah, so we just need to make sure we get you on the phone and then draft the document and get you in for an appointment. But that usually is a quick turnaround.
okay.
It takes longer for us to close your case and mail you your documents, but once the document gets recorded with the recorder of deeds, it's legally valid. So even if you haven't gotten it back in the mail, you're still safe in terms of.
Do you cover the cost? Is there a cost to recording that, or do you cover
We
that as
cover
well? Oh, fantastic. Okay.
If you
All
did
right.
it yourself, I think it's like $26 or something like that. It's not expensive, but we do cover it.
All right. Any other questions? Anybody want to raise their hand or just take yourself off mute and chime? Oh, Patricia, go ahead.
Yes, I'm thinking that most of the discussion is for folks who have owned their homes. What about the heirs where the person who owns the home took out a second mortgage with a predatory loan company like Aquan, and the person dies and you try to negotiate with the predatory loan, but they will not even talk to you because they say your name isn't on any of the documents. So have you run into scenarios like that?
Yes, I'm not sure which one you're describing, but when a homeowner is already passed away, and then are you in a scenario where homeowner passes away and there's nothing in writing, their heirs now own the home, though that's not reflected in the title records. So if there's a reverse mortgage on the house, that's one situation, and then there's just a regular mortgage on the house, that's a different situation. In both situations, you can get the heirs in a position to be able to speak with the mortgage company by doing the legal work that I talked about in terms of resolving heirs property. Maybe. I mean, it's different by mortgage company and it's very fact specific, but if you are trying to deal with the mortgage of a parent or someone who's already passed away, it's doable, but it can take some work.
Yeah. Yeah, I'll just be transparent. I lost a family home. My brother and I inherited it from, at this time, it went through quick claim deeds. First it was my sister, then she put a claim to the mother, but there was still a loan from Aquin on the property.
Mm-hmm.
And then when both of them died, I guess it was my role was to try to get hold of Aquin to try to negotiate something with them to
Right.
lower their amount. They would not even talk to me.
Right. So yeah, all mortgage companies are going to require, so they have a borrower. Whoever signed the mortgage is their borrower, and they're not authorized to speak with anyone who's not the borrower unless someone is named as what's called the successor in interest. So mortgage companies will talk to you if you are named the successor in interest to a deceased borrower. But the complicated thing is that each mortgage company has different rules for what it requires to become the successor in interest. And that's just to speak with you. So once you're a successor in interest, they'll speak with you and you can negotiate with them. But there's like sort of a gray area between the borrower dying and becoming successor in interest. It's going to depend on the mortgage company itself. So it's hard to say until you actually know the mortgage company you're working with.
Mhm. Yeah, okay.
Rachel, can you see what Tanya put in the chat?
Yeah, you would love a referral, Tanya. Happy to help. What are you thinking specifically?
Tanya, you want to come off mute?
Yeah.
Go ahead.
Sorry for the audio, but I think I just want just a referral to have to maybe draw up a plan, an estate planning for my homes,
I
because
see.
we have a couple of homes, and my husband, he's the benefit, we're on the homes together, but in case something happened to us, but we want to know what happens to our homes and property and things like that.
I see. You're looking for a referral to a private attorney.
Yes, yes.
Okay, yeah. If you email neighborhoods at legal services and ask for a referral to a private attorney, our paralegal can get you that.
Perfect. Thank you.
And there's another one there from Valerie. Rachel, can you see that one?
Yep. I believe my children are beneficiaries named in a trust / their grandmother. Okay. Yes, you can again email that email or use that phone number to call and describe your situation. One starting point is, does everyone know how to look up an address on the county or the city's website to see who is the owner?
I've done it. I couldn't tell you the exact process I went through, but I know I can do it if I just Google St. Louis County real
Yeah,
estate
totally.
records or something like that.
Mm-hmm.
It'll take me somewhere where I can go by address.
Yeah, so this is, oops, that's not the right link. Like for this situation, you'll always know if a property is owned by a trust. If someone put the property in trust, the records will say owned by the trust. And if they didn't, then you're looking for a will or beneficiary deed. And not sure from that note which situation we're in. But you could look up the address and see whose name is showing up or which trust's name is showing up.
Hi, this is Valerie. So it's a little more details, but it was in the name of the trust.
The property is in the name of the trust. So then it would be distributed according to the trust documents. So you'd need to find those trust documents if you have
Okay.
them.
The executor will not show them. And again, my children were minors, so I don't even know how that would work. They were minors at the time, so one of them's 18 now, and one of them she's 15.
So executor is a name for a will, and trustee would be the name for someone who's managing a trust. Is the trustee?
She's the same person.
So there wouldn't be both. Is it?
Oh,
there should
okay.
be both.
So she's the trustee then.
She's the trustee, and she's refusing to share the trust documents.
Well, because I guess I'm not named. I wasn't named in either of them, which is fine. But I believe the grandchildren are named. I believe wholeheartedly.
Well, it's the duty of the trustee to carry out the terms of the trust document. And if you believe that that's not happening, that you could litigate against the trustee. That's definitely not something our office does, but that's what would happen. But if the owner, the person who created the trust has died, and there's a house that's in the name of that trust, most commonly a trustee's deed should follow the death of the owner and put the house into the name of whoever was named to get the house. That's usually how houses in trust work. Owner places it in trust. There are terms of the trust that become relevant when owner dies, and they say house goes to these beneficiaries, and then the trustee executes what's called a trustee's deed to whoever was named in the trust documents.
How
And
long do they have to do that? I fear that.
I don't know. Yeah, and if it is strange, I will say it's strange unless the trust documents are very complicated, such that the house is going to remain in the trust forever. There usually would be a trustee's deed.
Okay. Can I still email you with another question?
You can, is it about the trust thing? It's probably, the trust thing is probably not something we can help with, but you can feel free to email.
Especially for maybe another referral.
Yeah, and even that seems like not an estate planning question, seems like an estate planning gone wrong question, which is a totally different type of litigation. So I'm not sure that we would have the right referral for you. But you can try us and we can see.
Okay. Thank you.
Okay, any other questions?
This is Dennis. I had a brief question. You started off the presentation talking about your interest was in avoiding vacant properties. And then ended with talking about adverse possession and squatters' rights. And so everyone's got their own story to tell. And my block is a vacant property that's been vacant for about 8 years. We know the previous owner passed away and the children are maintaining it. No one's living in it. And don't know what was going on, but we'd certainly like to see someone occupy the property rather than it set vacant. But just wondered if potentially they were leveraging taking adverse possession just by riding out the clock. Or if there's anything that a resident could do to assist them or refer them for additional assistance.
Yeah, it's a good question. Do you know if the house is still in the deceased parent's name?
According to county records, I believe it is.
Yeah, so there's a number of reasons it might not be updated. It might be that the heirs don't know that they need to update it. They might know, but not know that there's legal assistance out there that they can access. Or there might be some dispute among the family that's keeping them from updating title. And maybe they are waiting on that 10-year claim. The 10-year claim is most readily made by someone who lives in the property. That's when we will do that for clients. So if that's their strategy, it's probably not a strong one just to be mowing the lawn. But if you want to refer them, if you know them enough to refer them to us, that's usually a house and someone who's passed away name is a problem. It's going to be hard to get that property occupied again until that problem is cured. Whether it be by the heirs clearing title, or most often, eventually the heirs abandon it because they get frustrated and then it goes through tax foreclosure.
Right. And one of the things they continue to do is pay taxes on it and do a minimum amount of maintenance. And we do know them well enough that we can refer them. So we'll go that route. Thanks. Appreciate it.
Yeah, that'd be great.
Dennis, are you concerned that they just don't realize that they may be doing all this work on this house, but if they don't make sure that they have some kind of legal claim to it, they could find themselves without a home one time, not realizing they put all this work into the home for nothing.
Yeah, I, I don't think, it may be a mixed bag. I mean, they may have some, financial issues that are baggage that came with the house, some indebtedness, that needs to be resolved. So, I don't know.
Yeah, there could be debt. And they might not know if they update title, they can sell the house too and pay off whatever mortgage is there if the value is enough.
Right. I think there's some sentimental value, the
Mhm.
family home, and there may be some, conflict amongst the children, so that they need to work through as well. So,
We do, I didn't mention this, but we can refer families to mediators. So if all the family is together and disputing, that's the perfect situation for a mediation. Sometimes like the dispute is just that they can't get a hold of two family members. That's not a great mediation project, but if all the family members are present and they just can't come to an agreement, we can refer to free mediation services to try to help them come to some kind of resolution.
okay.
Valerie, do you have your hand up still? You want another question?
No, I'm sorry.
Okay, all right. All right, any other questions? Any other concerns? Now you brief statement you made, Rachel, something along the lines of, because you asked about is it a will or is it a trust? Do you not need both? I thought we were always kind of told you need both, but you don't need both?
Speak with an attorney. It depends on how complex your estate is.
Okay,
We do
let's
not do
keep it
wills.
simple.
Yeah, we don't do wills for any of our clients whatsoever because of that 1 year probate rule. And most of
Okay.
our clients are not people who are gonna have heirs who are paying for an attorney to probate their will within 1 year.
Okay,
People with complicated estates will do backup wills where the will is just there to capture anything in the event that their attorney failed to capture an asset in their other documents. The will is there as like a backup plan, a backup scoop for, the car in San Diego that no one remembered to put into the estate plan. Then you have this will as a backup. So probably if your attorney is the most vigilant in the world, they will give you a backup will. We don't offer those for our clients, but if you want one because you want to make sure everything in the world is covered, you can get one.
okay. So if I just have simple things, I've got a house, a car, the furnishings, a little bit of jewelry, savings account, and some retirement money. Can I just do a trust and that will list it all and not have to make my kids to pay an attorney to go through probate? Is that as simple
Yep.
as it can be?
You could
Okay.
do a trust or you could do beneficiary designations for all of them.
Okay, all right. Yeah, I didn't realize you could do that I saw that for the car and for your bank accounts and all of that too. Okay.
Yeah,
Okay.
so you can scoop all of your assets into one trust. Everything gets titled into that trust and then the trust documents distribute it when you're gone. Or you can do your beneficiary designations one by one through each type of asset. Trust is going to be more expensive, more complicated. There's those trust documents. You need to have a trustee. The transfer on death is just, you do it while you're alive, and upon your death, it's automatic to whoever you named. And then the will is that probate court mandatory universe where you're going to need an attorney.
Okay.
I have
Okay.
another question, please. So
Go ahead,
how can you make the trustee show you the trust? So if my kids are minors and I believe that they were left something, how can I get her to show me the trust to see if that's true?
Right, yeah, I don't know the answer to that question since we don't deal with trusts, but if you believe that there's a negligent trustee, then I'm sure there's a type of litigation, but without the trust documents, you don't have a lot to stand on.
I don't.
Besides your gut feeling. So gonna have to find a creative attorney to make that claim for you.
But does it make a difference? I think one time she said one of them is now 18, so is that now legal age that
If
may
you
move the trustee
knew-
to
Yeah, so
reveal?
this is getting into territory that, again,
Okay.
I do not know about, but there's a concept of standing, like who can bring a claim in court.
Okay.
And you must have some relationship to the dispute in order to bring the claim in court. Those kids would have standing if they were beneficiaries who were being, who were not getting the asset that they deserved, but we don't actually know that because we've never seen the trust documents. But no, their age doesn't make a difference unless in the trust document, which you have not seen, it says, this house goes to so-and-so, but trustee, who is named here, you shall not give a deed to them until they reach X age. That could be in there, we have no idea. And if that is in there, then it's the trustee's obligation to give the property to whoever at X time.
Okay. I'm still a little twisted up, but what happens if, so there was a probate situation, it did go through probate because there was a will. And the heir was named in CaseNet.
Okay,
Okay, and then again, there's no assets being given. So it's the answer is the same, basically. So we still have to find somebody to pursue.
well, that does confuse me quite a bit, what you just said there, because if you're in probate court, it sounds like there's a will, not a trust. Which
There
is
can, but
totally,
there can be
different.
both though, right?
there could be, but is the house in the name of the trust? Because
believe-
then the will is irrelevant. If the house is in the trust, then the will is irrelevant. But if the house is not in the trust, it's gonna get distributed according to the will.
Okay. Got it.
Mm-hmm.
Does one supersede the other? In other words, if it's written one way in a will, but it's written to a different beneficiary, the same thing in a trust, does the trust override the will, or does the will override the trust? Or hopefully a good attorney won't make that won't make that
Yeah, so with a
mistake.
beneficiary designation, if you have a transfer on death beneficiary, a will cannot later change that.
Okay.
Once you make your beneficiary designation, unless there might be some specific language you can put in your will, but if you already have a transfer on death for your house with a beneficiary deed, and then in your will you put house goes to someone else, the beneficiary deed rules.
Okay.
Unless you put something in there like, I'm saying this knowing that I have a beneficiary deed to the contrary and specifically intend to override said beneficiary deed. For a trust, what you're doing is actually putting the asset into the trust and removing it from your estate. So your estate is your pool of things that you own when you die.
Okay.
You don't own the house anymore. The trust owns the house. So your will only governs the things that you own. And since the trust owns the house, not you, whatever's been deeded over to the trust is distributed by the trust. Whatever you still own goes by the will or by your beneficiary designations.
Okay. Okay. Any other questions or concerns? Cindy did also put in the chat her phone number then, because she obviously as a real estate agent has worked with several real estate attorneys as well. So she may be able to give you a referral also. Okay. And that's why we're trying to do these things now, to have these conversations with attorneys so that we get a better idea of how to avoid these complicated situations when we pass on, because I don't want there to be any question or problems when I walk away. Everything should be clear. Everybody should know. And that's key. Everybody, in my opinion. I mean, cousins come out the woodwork when people die. And all of a sudden, no, she promised this to me. No, that was promised me. Yeah, all of that. Yeah, we can avoid all of that by simply getting a lot of this written in writing before we go, and and that's the hard part. Sometimes you don't want to tell everybody that
Mm.
they're not your favorite. Yeah, but Cindy, I see
I
you're
was
back
just
on.
gonna say, just to chime in, because as a real estate agent, you see all kinds of stuff.
Mm,
And, I had a resident who, I don't even know where she got my name and number, but she was in hospice and she had inherited her house from her mother and wanted to leave it to her kids, but it was in foreclosure
Mhm.
because, and there was nothing, it was so far down the path, there was nothing that could be done.
Mm.
mm,
Mhm.
And all those things that you talked about, right? We were trying to talk to the bank, they wouldn't,
Mhm.
and by the time we could get all the necessary paperwork together for her, it was on the courthouse steps.
Mm.
wow.
It's important to protect your assets.
Totally.
Yeah, very much so. Very much so. And it's, as I mentioned earlier, a lot of times it's, especially our homes are the largest asset many of us will ever own. And it's enough of an asset that when we go, that can really pass wealth on to children, even if they have to be split up between, you sell it and split it up between multiple children. It'll be enough most of the time of a down payment that they can now buy their own home. And that wealth just continues down the next generation and the next generation too. So that's important. So it's
Mhm.
the best thing to keep our future generations also out of poverty. It's owning your own. Okay. Any other questions? Well, I will tell you something. For something that started off a little rocky, and I'm glad you all stuck around and came back on, this was one of the most engaging and interesting webinars that we have held. We had a series of 4 last year. We'll have 2 more coming this year. This was probably the most engaging conversation we've had in a long time. So there's a lot of interest out there. Do take advantage of the services offered by the Legal Services of Eastern Missouri if you need a little bit more guidance or referral. So we make sure that we're ready to go, literally, and that our kids or our heirs will be protected. I thank you so much for Rachel. Thank you for sticking around, and thank you everybody else for joining us too, and thank you for sticking around as well. This recording will be on the Shed website, which is https://shed SHEDSTL.org, so that you can listen to it again, or you can refer it to maybe somebody else in the family that needs to listen to it as well. So with that, I thank you. I thank you all for being with us this evening, and I wish you all a great evening. Good night, everyone.
Thank you.
Night.
Good night.
Bye. Thank you, Reggie.